Good morning. Today I will discuss standard form contracts and the rules developed by court regarding standard form of contract. The standard form contracts contain a large number of terms and conditions. Mostly, these terms and conditions are in small print and written in such language and style often seems irrelevant and unnecessary to person. Such terms often exclude liability of big company or large scale organization under the contract. It would be difficult for large scale organization to draw up a separate contract with every individual or with every customer. To negotiate contract on individual basis is time consuming and it is a costly affair. And so now contracts in standard form is in practice in many or rather in most fields of business. One of the object of this standard form is to save time. In other words, the big company exploits the weakness of the individual customer by incorporating such terms which may exempt the company from all liability under the contract. The courts are in these circumstances are called upon to save and rescue the weaker party who deserves to be protected against the possibilities of exploitation in such contracts. Following modes which are evolved or developed by the courts in this regard. The courts have evolved and applied certain rules that is to protect the interests of the consumer or customer or passenger as the case may be upon whom standard form contracts or exemption clauses are imposed. Like reasonable notice should be given, notice should be contemporaneous or simultaneous with contract, theory of fundamental breach, interpretation of the contract, liability in tort, exemption clauses, and third parties, etc. So let us discuss in detail. The first one rule is developed by the court is reasonable notice or notice should be reasonable and proper. Adequate notice to the offeree. Offeree means to whom the offer is given, that is acceptor. When he accepts the offer, he will be called as acceptor. So adequate notice to the offeree, that is to the customer or consumer of the printed terms and condition must be given or to be given. It is the duty of the person who is delivering a document to give adequate notice to the offeree of the printed terms and conditions. Where it is not done, the acceptor will not be bound by such terms. In Henderson versus Stevenson, the plaintiff bought a steamer ticket on the face of which these words only written, that is, Dublin to Whitehaven. On the back were printed certain conditions, one of which excluded the liability of the company for loss, injury, or delay to the passenger or his luggage. The plaintiff did not see the back of the ticket, nor was there any indication on the face about the condition on the ticket. On the back, the plaintiff's luggage was lost or destroyed in the shipwreck caused by the fault of the company's servants. This was laid by the House of Lords that the plaintiff is entitled to recover the loss which he suffered from the company in spite of the exemption clauses. He was entitled to recover the loss on the ground that sufficient notice of the presence of the terms and conditions was not given. Second rule, Notice should be simultaneous with the contract. Notice of the terms should be given either before or at the time of the contract, but not later. A later notice amounts to modification, and therefore the notice must be given before or at the time of making of the contract. In Oli versus Melborough Court Limited, a couple, that is plaintiff and her husband, hired a room in defendant's hotel for a week. They paid rent for boarding and lodging in advance. When they went to occupy the room, they found a notice displayed, that is in the room, and the notice stated proprietors will not hold themselves responsible for articles lost or stolen unless handed to the management for safe custody. But due to the negligence on the part of the hotel staff, the plaintiff's property was stolen from the room. In an action against the defendant, that is the hotel proprietor, to recover the compensation for the loss, they sought exemption from liability on the basis of the notice displayed in the room. It was held that notice in the room was not forming the part of contract, and therefore the defendants were liable to pay compensation. Proprietors were held responsible because the notice was subsequent, that is afterwards, that is later, and not a part of agreement, and therefore they were liable to pay compensation. Third rule, theory of fundamental breach. This is yet another method of controlling the unreasonable consequences of wide and sweeping, that is far reaching exemption clauses. Every contract contains a core or fundamental obligation which must be performed. If one party fails to perform this obligation, he will still be guilty of breach of contract, whether or not any exemption clause has been inserted which purports to protect them. In case of Alexander versus Railway Executive, the language of the the luggage of the plaintiff was in custody of the defendant. A luggage was deposited at the clock room of a railway station, and the plaintiff he received a ticket. A receipt thereof contained conditions, one of which exempted the defendant, that is railway company, from liability of misdelivery. In this case, the plaintiff's luggage was delivered to another person who was not even required to produce the ticket or receipt. A luggage was in fact misdelivered. The defendants were held liable in spite of the exemption clause. The court held that it was fundamental breach of contract. The defendant had committed a fundamental breach of contract in allowing an authorized person to have access to the goods. They could not therefore rely on the exemption clause to shield them from liability. Fourth rule, construed strictly, or we can say strict construction, where exemption of clauses in standard form contract are to be strictly and narrowly construed, or construed means interpreted in favor of the individual who has to perforce adherence to the contract and not in favor of the company. Means here the person who has to perforce means majburan vivashta se, adhere means palan karna. to the contract and not in favor of the big company or big organization. Exemption clauses are normally construed strictly or interpreted strictly, particularly where a clause is so widely expressed as to be highly unreasonable. If there is ambiguity in construing an exemption clause, in interpreting exemption clause, the court will resolve it in favor of the party uh, who is weaker, that is in favor of the weaker party, and here weaker party is customer or consumer. The doctrine of contra proferentum, that is Latin term or Latin doctrine, that means against the offerer. This also known as interpretation against the draftsman, means who drafts the agreement. So contra proferentum is a rule of construction applying to or written documents or deed. The rule provides that if the wordings of an agreement is ambiguous or uncertain but not otherwise, the contract should be interpreted or contract should be construed more strongly against the person whose words they are rather than the other property. So here the wordings are of the big companies or big organization, and therefore it should be interpreted against the strong party. If a party has incorporated its own standard terms and conditions of trade into an agreement, then in the event of ambiguity, those terms and conditions will be interpreted or construed contra proferentum that party. Let us discuss example case law. Lee and Sons Limited versus Railway Executive. Fact of the case: goods stored in a railway warehouse led to tenant were damaged by fire. A spark from the engine, that is railway engine, caused fire and damaged goods stored. And the tenant brought an action against the railway executive, alleging that the accident was due to their negligence because a spark ejected from their railway engine had caused the fire. The defendants, that is, the railway executive, had set up a clause in the tenancy agreement which exempted them for loss of or damage to property, however caused, whether by act or neglect, neglect of the company or their servants or agents or not, which but for the tenancy hereby created would not have arisen. The defendant had set up a clause in the tenancy agreement which exempted them for loss of or damage to property, however caused, which but not but for the tenancy thereby created would not have arisen. It was held that the company was liable. The defendant was nevertheless held responsible. Even though there was exemption clause, here the defendant was held responsible. The words but the tenancy thereby created were confined to liabilities which arose reason of the relationship of landlord and tenant. Fifth rule, liability in tort. Tort means a wrongful act leading to civil legal liability, that is known as tort. For example, public nuisance is a tort. So, liability in a tort, it is well settled now that even where an exemption clause is enough to exclude all kinds of liability under the contract, it may not exclude liability in tort. Courts have also consistently held that even where liability in contract is excluded by way of standard form contract, tort liability may still be fastened for negligence, etc. It cannot be excluded under the tort. Example: W hired a cycle from J. J agreed to maintain the cycle. A clause included in the agreement provided thus nothing in this agreement shall render the owner liable for any personal injuries. While riding the cycle, the saddle tilted and W was thrown and injured. The court held that though the clause exempted J from their liability in contract, it did not exempt them from liability in negligence. It did not exempt them from liability in tort. Number 6, terms unreasonable. A term is said to be unreasonable when they defeat the very purpose of the contract, or if it is repugnant, that is contrary to public policy. Example: a laundry receipt here T is missing. A laundry receipt contains a condition that the customer, in case of loss of article, will be entitled to only 15% of the market value of the articles. So, this clause was found to be unreasonable because this condition was held to be in flagrant infringement of the law relating to negligence. The cleaners must know that the articles worth a lot of money are handed over to them for cleaning, and it would be most unreasonable to limit their liability to a ridiculously low figure. And therefore, though exemption clause was inserted, the cleaners or dry cleaners were liable. Number 7, effect on third parties. The terms of the contract strictly binds the parties to it, and no third party can either enjoy any right or suffer any liability under it. This principle also applies equally in case of standard form contracts. Thus, where goods are sold under contract which exempts the supplier from liability, and if a third party is injured by the use of them, the supplier will be liable to the third party irrespective of the exemption clause. Let us discuss example. A contractor agreed to maintain and repair the lift. The contract with the owner exempts him from liability. That exemption clause, however, will not save the contractor against a third person who is injured because of bad repairs. If this is not if this was not the case, the life and safety of millions of them using the articles would be totally in hands of the two parties to the contract. This duty to the third party does not rise out of contract, but it is independently of it. Example: a sea live company exempted itself from any liability to its passengers for the negligence of its employees. A passenger was injured by the negligence of one of its employees. The passenger was held entitled to sue the negligent employee. The employee could not avail of the benefit of the exemption clause. So here we can conclude that a standard form contract prepared by one party to be signed by the party in weaker position, usually a customer or consumer who has little choice about the terms. These contracts are produced by the printing press. We can say that these contracts are produced by the printing press. The pen of the individual signed on the dotted line does not really represent his substantial agreement, or that does not really represent his consent, because he has to accept the terms and condition as it is with the terms in it, but creates a fiction that he has agreed to such terms. It seems like this contract are pretended contracts that have only name of the contract.